Hi, everyone. Thank you so much for joining us today. My name is Shiwali Patel. I use she, her pronouns, and I'm with the National Women's Law Center, the Director of Justice for Student Survivors. So today you'll be hearing from experts, including students and other advocates and leaders, about a significant development that came out today. As you all know, the Biden administration released a Title IX rule that has culminated from years of advocacy from the groups represented here and many, many others. As you'll hear from our panel of speakers, this Title IX rule provides important clarification and protections for student survivors, pregnant parenting students, and LGBTQI plus students. However, it doesn't go far enough. So while we are celebrating this, we're still working to ensure that the Biden administration continues to fulfill its promise to trans, non-binary, and intersex student athletes. I am very pleased to announce our panel of experts, who include Brandon Wolf with the National Press Secretary of the Human Rights Campaign, Olivia Hunt, the Policy Director of the National Center for Transgender Equality, Kenyora Parham, the CEO of End Rape on Campus, Kel O'Hara, the Senior Attorney with Equal Rights Advocates, Emily and Andrew Davis, both student organizers with Know Your Nine, a project of advocates for youth, and Melanie Willingham-Jaggers, the executive director of Listen. As you may know, this rule, including the preamble, is over 1,500 pages long. So please bear with us as we are still reading this rule and understanding the full scope of what it means. If you have any questions during the panel, while our experts are speaking, you can drop them into the Q&A, and please specify who you would like to respond to your question. And with that, let's get started and hear from Brandon Wolf with the Human Rights Campaign.
Thank you so much, Shiwali. Good afternoon, everyone. Thank you to our friends for convening us today. Thank you to the members of the press who've joined us. As mentioned, my name is Brandon Wolf. My pronouns are he, him, and I serve as the National Press Secretary for the Human Rights Campaign. I like to say that it's a good afternoon for good news. There's good news to celebrate today. This is truly an historic and important day because Title IX is a crucial piece of protecting students from discrimination and making sure they have exactly what they need in order to thrive. Let's make no mistake that today's rule will be life-changing for so many young people, including LGBTQ plus youth, pregnant and parenting students, and survivors of assault. This rule means that pregnant or parenting students won't be forced out of the classroom. It means that survivors of sexual assault have the stronger protections they deserve. And yes, it means that queer young people can go to prom and other school dances with their crush. They can paint their LGBTQ plus families on canvases and weave them into the stories they write. To put it simply, this rule is a reminder of what Title IX has always been designed to accomplish for its more than 50 years. And that's to ensure that students are safe from abuse, harassment, and discrimination while they pursue their education. Now, the next step is that school administrators have to take note of this rule. They have to immediately act to implement anti-bias and anti-bullying and harassment programs that ensure misgendering stops, that cruelty against LGBTQ plus students ends, and that every single student has access to an education that is free of discrimination. I'll put a little plug in here if those administrators need support with that. The Human Rights Campaign's Foundation's Welcoming Schools program is a comprehensive bias-based bullying prevention program that's designed to provide LGBTQ plus and gender inclusive training and tools to educators. I also have to just for a moment share some gratitude for everyone who has worked tirelessly to make this moment possible. It's important for us to say that this new rule did not come about by accident. It's not happenstance. This rule was propelled by the fierce and unwavering leadership of communities across the country. Folks have advocated for years from coast to coast and beyond to urge multiple administrations to protect students from discrimination in schools. That tireless advocacy was led by all of our partners who are represented here on the call and, as Shiwali said, so many others. This coalition has stood strong across communities with a vision for what protecting young people can look like. So I want to say from the bottom of my heart, thank you, thank you, thank you for your work to give every student the chance to thrive. And as Shiwali said, even as we celebrate this progress, our work is far from finished. LGBTQ plus Americans, particularly transgender young people, continue to endure ongoing attacks on their rights and their dignity at the state level. So we call on the Biden-Harris administration, as we have, to move swiftly to ensure that Title IX protects the rights of transgender athletes to play and be part of a team. And there are also critical protections in healthcare broadly, including veterans care, that are long overdue. So I say all of that because for me, today is a perfect reminder that when we put in the work together, a better future is absolutely on the horizon. I'm excited to get that job done.
Thank you, Brandon. And I see we have a question in the Q&A, and I think that will be addressed later on by one of our speakers. So now I will move it on to Olivia Hunt from the National Center for Transgender Equality.
Good afternoon, everyone. My name is Olivia Hunt, and I'm Policy Director for the National Center for Transgender Equality, or NCTE. And I really appreciate this opportunity to talk today about what the final Title IX regulations mean for LGBTQIA plus students, and particularly for transgender and non-binary students. Over the past 5 years, an ever-increasing tide of anti-LGBTQIA plus legislation has been introduced in state houses around the country, with each year exceeding the last in sheer number of pieces of hostile legislation introduced. The overwhelming majority of these bills are targeted squarely at transgender and non-binary youth, whether limiting their access to medical care, attempting to silence and erase them in their schools, or threatening the parents who are supporting them. Anti-trans extremists in political office have made it a key part of their agenda to push trans youth out of public life and make it seem like they have no place in their communities. With today's regulation, the Biden-Harris administration takes an important step toward pushing back on these attacks. These new rules make it clear that the general provisions of Title IX prohibiting discrimination on the basis of sex protect trans youth from harassment and discrimination in education because, as the Supreme Court stated 4 years ago in Bostock v. Clayton County, it's impossible to discriminate against a person because of their sexual orientation or gender identity without discriminating against them based on sex. The regulation makes it clear that the general provisions of Title IX also protect gender nonconforming and intersex students from harassment and discrimination. This means that trans students may not be barred from any covered educational programs on account of their gender. This means that trans students may not be denied access to restrooms, locker rooms, and showers consistent with their gender. And this means that dress codes may not be applied against trans students in a discriminatory manner. It also means that trans students may not be subjected to invasive examinations to prove their gender. So this is a bold and important statement that transgender and non-binary students belong in their schools and in their communities. Unfortunately, there are a few remaining ambiguities to these regulations. For instance, while harassment on the basis of sex is prohibited, misgendering, dead naming, and other specific forms of harassment faced by trans students in particular are to be treated on a case-by-case basis. In addition, the department's declined to include explicit protections to ensure that trans students have access to safe and appropriate housing consistent with their gender. And finally, none of the provisions in the regulation apply to athletic programs. The campaign of exclusion against trans youth nationwide is focused on pushing trans youth out of gym classes and sports teams consistent with their gender. The message we're hearing from trans children of all ages is clear: let us play. We urge the administration to move quickly to finalize their athletic rules to make it clear that in communities nationwide, trans children belong. And I'll hand it back over to you, Shiwali.
Thank you, Olivia. And next we'll hear from Kenyora Parham with End Rape on Campus and Kel O'Hara with Equal Rights Advocates.
Thank you, Shiwali. Good afternoon, everyone. My name is Kenyora Parham, and I am the Chief Executive Director of End Rape on Campus.
And my name is Kel O'Hara, and I'm a Senior Attorney of Policy and Litigation at Equal Rights Advocates. Thank you all so much for joining us today as we address the critical changes to Title IX regulations under the Biden administration and their profound impact on student survivors.
And let me begin by underscoring what every student deserves: their freedom to be themselves without fear of harassment or discrimination. It's this promise of equal educational opportunities that Title IX was meant to safeguard over 50 years ago, as my colleagues stated at the top of the call. And we are pleased to see these new rules and the many significant changes, especially during Sexual Assault Awareness Month. Under the Biden administration, the Department of Education's revisions to the Title IX regulations are a necessary step in reversing the deeply stigmatizing, racist, sexist, anti-LGBTQ plus and ableist standards imposed by the 2020 regulations. Simply put, students will no longer have to endure an additional year under the Trump 2020 rule. They restore Title IX's promise of strong protections for student survivors, particularly those from historically excluded and marginalized communities, including pregnant and parenting students, and those who identify in the LGBTQIA communities. So I'd like to address several key areas and to highlight that. So to start, the Department of Education makes it unequivocally clear that the definition of sex discrimination is inclusive of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. Furthermore, the definition of sexual harassment has been expanded from behavior that is severe, pervasive, and objectively offensive to unwelcome sex-based conduct that is sufficiently subjective and severe or pervasive that it denies or limits a person from achieving education. This broad and bolder stance means that students, regardless of their identities, but with respect to their identities, will no longer have to endure repeated harm before schools take appropriate action to address sex discrimination and harassment. Schools with knowledge of an incident are federally obligated and responsible to address reports promptly and effectively.
Next, these changes require schools to address Title IX complaints that meet the restored definition of sexual harassment, including incidents that occur off campus or abroad, and complaints that arise after the survivor is no longer enrolled at the school. This ensures that no survivor's experience is dismissed or ignored based on technicalities. Thirdly, the new regulations put an end to unfairly and traumatic grievance procedures that favor harassers. This means that live hearing and cross-examination requirements have been removed. No longer will student survivors be subjected to processes that prioritize the interests of their perpetrators over their own well-being and safety. Moreover, the Department of Education's changes ensure that more students have access to the resources they need to feel safe and supported at school, regardless of if they file a formal or informal complaint. This includes comprehensive and culturally appropriate support services and accommodations to aid survivors in their recovery and pursuit of education. It is imperative that Title IX ensures fair and equitable processes for all students experiencing sex-based harassment. These changes are crucial in creating safe and supportive environments for survivors to come forward and seek justice without fear of retribution or dismissal.
And while my colleagues have spoken about the new Title IX regulations' impact on LGBTQIA students, especially those who identify as transgender, non-binary, and intersex, I want to provide just further attention to another important group, and that is pregnant and parenting students. Under these new Title IX regulations, they offer much needed clarity on their rights. These changes explicitly prohibit discrimination based on lactation and ensure that students can't be excluded from school activities based on regressive stereotypes. Additionally, schools are now required to reasonably accommodate pregnant and parenting students, including providing lactation rooms and accommodations that are needed prior to and post-delivery. Pregnant and parenting students deserve better. They now have better, and they deserve the resources, accommodations, and supports that are mandated under the federal rule. They shouldn't have to have their education derailed or face discrimination or stigma. And that's why these new rules are essential for ensuring that these students, along with many others, feel seen, heard, and believed. So in conclusion, under the Biden administration, the Department of Education's revision to the Title IX regulations signal a significant shift towards a more inclusive and supportive educational environment for all students. And by prioritizing the rights and well-being of survivors, we can foster a culture of accountability, empathy, and safety in our schools. This allows us to be one step closer to where all individuals can earn an education free from violence. Thank you. Back to you, Shiwali.
Thank you. And I see we're receiving some questions, and we will get to your questions after our remaining speakers go. And so our next speakers are Emily Bach and Andrew Davis, who are student organizers with Know Your Nine, a project of advocates for youth.
Hi, everyone. Thank you for being here. My name is Emily Bach, and I'm a student engagement organizer with Know Your Nine, a survivor and youth-led project of advocates for youth working to end sexual and dating violence in school. I'm also a senior at Columbia, which means I've spent my entire college experience under the Trump Title IX rules. Over the last 4 years, I've worked alongside hundreds of student organizers in high schools and colleges as we fought for stronger Title IX protections. Today, I'm grateful that our advocacy has ushered in a new, more just era for survivors and students in schools. I'm also devastated by the number of students I've met who were forced to advocate for themselves, their loved ones, and their communities to get us here. Over the last 4 years, I've sat beside countless survivors as they questioned whether they would ever see justice through Title IX for the harassment and violence they encountered. More often than not, the answer was no. I'm grateful that under the new regulations, many more survivors can seek justice, accountability, and resources to help them heal and pursue their education without disruption. I look forward to working with the Biden administration to support schools in implementing equitable, fair Title IX processes. We still have much more work to do to expand students' faith in Title IX, protect LGBTQ+ student athletes, and ensure all students have access to the resources they're entitled to under this rule. But today is a day of celebration for student activists, our advocacy, and the new era these rules usher in.
Hi, all. My name is Andrew Davis. I'm a graduate student, researcher, and survivor justice organizer. Like Emily, I too have spent my college career under the Trump and DeVos era Title IX regs. As a queer and disabled student survivor who went through that process, I know firsthand how harmful it is and how desperately we needed this new Title IX rule. From requiring training for all employees and redefining sexual harassment to expanding supportive measures regardless of an investigation and strengthening protections for pregnant and parenting students, including those seeking access to abortion care, these rules have the potential to make a profound and lasting impact for all students at all levels. With these new protections in place, it's absolutely essential that the Biden administration actively works with students and survivors to ensure and prioritize the quick and effective implementation of these regulations by providing guidance and oversight to the school administrators responsible for this. As an organizer who's worked with hundreds of school officials on how to best support survivors, I've learned just how critical policy implementation really is. And as my fellow organizers who are still in high school have shared with me, this is an especially true concern for students in K-12 schools, which frequently lack the infrastructure and oversight to really support all students pursuing their education free from discrimination and violence. However, we must also acknowledge that this rule doesn't go far enough. We need the Biden administration to immediately release the athletics rule and ensure that transgender, non-binary, and gender non-conforming students have access to every part of the educational experience they're entitled to, including the full ability to participate in school sports. The fact that this athletics rule is still missing means we all have a lot more work to do. So as we celebrate today's announcement, I urge us all to continue to fight for even stronger protections and work to both rebuild trust in Title IX and create a Title IX process that is finally worthy of that trust with these new rules in place. To be clear, this is definitely a major step in the right direction, one that I know will impact countless students and survivors. While I wish we would have had this rule 3 years ago, today, I'm just so excited and grateful to be able to introduce a new generation of students to a Title IX rule that really fulfills its promise to protect students and survivors. Thank you.
Thank you. And thank you so much for your advocacy, as students just doing this important work. And so now we're going to pass it on to Melanie Willingham-Jaggers, the Executive Director of GLSEN.
Hi, good morning from the Central Time Zone. Good afternoon from the East Coast. I am proud to be on this call with my colleagues and comrades in this fight. We have done a lot of work together, and we are here because of the work of everyone on this call. So I want to extend my first heartfelt thanks, appreciation, and congratulations to everyone here. We got this done, and we got the administration to move on a thing that is long overdue, much needed. And there is room to celebrate as there is room to continue our advocacy moving forward. At GLSEN, we believe that education is the cornerstone of democracy. And as such, we need to make sure that every single student gets to participate in every single part of school life. This Title IX rule helps to increase and expand the ways in which young people from K through all the way through their college and experience and beyond in education have access to their civil rights being reflected and respected. So this Title IX, as my colleagues have already said, I'm just going to go over a couple of talking points from GLSEN's point of view. This Title IX protection clarifies the U.S. Department of Education their regulatory updates enforcing Title IX protections for LGBTQ+ students, student survivors of sexual assault, and pregnant and parenting students, which is a major accomplishment. Following the precedent set by Bostock, the department clarifies that harassment based on sexual orientation, gender identity, or sexual characteristics violate Title IX. The department emphasizes that access to facilities like bathrooms, locker rooms, accommodations, and sex education classes should and must align with an individual's gender identity, ensuring inclusivity. Of course, there are ongoing challenges, right? So despite our progress, discriminatory policies persist at the state and local levels, targeting queer and trans and non-binary and intersex individuals. This must be resolved. 10 states have implemented bathroom ban laws, right? While others have adopted pronoun bans and policies restricting trans, non-binary, gender expansive, and intersex youth from participating in school sports, posing significant challenges, particularly on the most excluded, most vulnerable, and those with the least voice. This is not okay. We are grateful for the ways that Title IX clarifies what is out of bounds. We are grateful for an administration and Department of Education that is aggressively pursuing enforcement. We are grateful. And I just want to lift up that the most marginalized students, particularly in K through 12, but also including those on college campuses, ought not be saddled with the responsibility of enduring harm and then fighting for enforcement. There needs to be a proactive stance. And of course, our advocacy continues in this way. But just to lift up that the obligation and the burden should not be on a next Benedict, should not be on other young people who are facing ongoing and persistent harassment and violence to get adults who know better to act right. Finally, at GLSEN, we are emphasizing the need for robust enforcement of Title IX, as I just said, right, particularly to invalidate discriminatory policies that have run wild and run rampant in the 3 years that this Biden administration has been silent on this issue, particularly around this updated rule. Again, we are grateful. Today is a day for celebration of significant and important progress. And we know that ensuring equitable access to educational opportunities for all students is ongoing and needs to include all students everywhere in every space. And so the fight continues. So again, congratulations to my colleagues. Thank you all for being here for this discussion. And we look forward to comprehensive and further expanded rights and protections for every single young person in every single educational space that there is moving forward.
Thank you. And so now we're going to move on to the Q&A, and the first question I have in the chat, which I think also folds in the question in the Q&A, and this question is directed to Olivia. So for Olivia Hunt, I think you addressed this as well, but we wonder how physical education classes, access to locker rooms, intramural sports, etc., fit, and whether denial to any of those activities or facilities are concretely considered discrimination under these regulations.
So, Shiwali, as mentioned earlier, it is 1,500 pages, and we're still parsing what it all means. But from the text, it does seem like access to locker rooms in particular is contemplated under this, but there's ambiguity when it comes to other education or other athletic programs, in particular where gym classes would fall under this. And if anybody who has had a chance to read more of the rule actually has some clarification on that, please feel free to jump in. But gym classes in particular were contemplated under the separate athletics rulemaking alongside intramural and interscholastic sports. So those would together not be covered under this regulation, as we understand it.
Olivia. Are there any other questions? Just checking the Q&A in the chat. Okay, there is a question that's coming. There is a question. Can you talk about how misgendering a student could be handled under these new rules? Would that arise to a hostile environment? Who would like to take that question?
I feel like Olivia, you probably have thoughts on this as well, but I can just say that in our initial reading, it means that schools cannot intentionally misgender students. It opens the dialogue about whether or not that would constitute a hostile environment, especially whether or not there is this pattern of bullying against LGBTQ plus students. And it also means that schools could not retaliate against students who complain about harassment or discrimination. So that's some of how we've initially read it. Again, it's very long, so we're continuing to pore over it. And Olivia, I don't know if you have other thoughts beyond that.
Sure. Sorry, looking over at my notes over here. So it seems like from the way it's being described here, the intent is that a single one-off instance of misgendering or dead naming a student wouldn't necessarily constitute a hostile environment in terms of harassment. However, an ongoing campaign likely would, which is why I was talking earlier about kind of the ambiguity around this area under the rule. That said, if somebody is in a situation where they feel like they are consistently being harassed by being misgendered, dead named, or in other ways, referred to inappropriately in an educational setting, they should absolutely look to this rule as a tool they can use to help vindicate their rights.
Thank you. And we have a question in the Q&A. What would you all as advocates like to see in the Title IX rule implementation process? What should schools be doing to make the policy change go as smoothly as possible? Imagine a few of you might have thoughts on that. Would anyone like to respond?
I can jump here. Yeah, so first I'd like to point people to our website, glisten.org/title-ix, so Title IX, for additional resources and real deep dives on what everyone can do, right? So it's guidance for students, student activists, it's guidance for educators and administrators. And also, just as Brian offered earlier, I want to just plug that GLSEN is available also for technical assistance and training, where school administrators and district leaders have questions. We are happy to come in and help you all kind of address, identify, and create a plan around it. Primarily, I would offer that, again, we've got these resources. I would suggest that folks dig into them, and where you have questions, happy to field those questions at GLSEN.
Thank you, Melanie. Oh, go ahead, Kenyora.
No worries. At NRAPE on campus, we, particularly when it comes to the implementation process, we want to make sure that that process is one that prioritizes survivor-centered approaches, also accountability and transparency in such processes, and making sure that there's clear guidelines and trainings for staff, administrators, and faculty, I would even say, really urging schools to provide that clear and comprehensive training for those populations as well as for students. And I would say things that are above and beyond that of orientation, but more consistent trainings. And then, of course, prevention and education. So, making sure that they're prioritizing prevention efforts, educational initiatives to really create a campus culture that condemns sexual violence and promotes healthy relationships. And so I'd love to see that. And I would even say, accessibility to resources. So being very mindful of student survivors and students in general with respect to their identities, and making sure that they have access to things like counseling, whether it's on or off campus, even legal assistance and other academic accommodations that can be readily available. That's what I'd say.
I'll add that, at Equal Rights Advocates, really saw that the lack of flexibility, the very strict way that things were mandated under the Trump era rule was very challenging for schools. And something that is an advantage of the Biden rule is that there is more flexibility for schools to make decisions around the processes within the rules that are best for their educational environment. And what I would say is that I'd really encourage schools to take that flexibility seriously and to take advantage of it, to make sure that they're being really thoughtful about the processes and procedures that they implement, that they're taking full advantage of that rather than using it as a way to skirt their responsibility or take a step back and choose the easy way out.
And also one more thing to add is that what I found to also be helpful is by engaging us as stakeholders as part of the process as well. Especially we can also make sure that the students are also engaged in these processes. Feedback is definitely important, in order to address concerns and in order to make sure that the policies that are being implemented are being effectuated, effectively and proactively, and with respect to the voices that are being shared. So I just want to add that, engage stakeholders.
Yeah, I think that's a great point to underscore from my perspective as well. We have a lot of data and information behind how LGBTQ plus students in particular interact with the educational environment. And I think that can help schools to identify gaps in their own systems and structures. And then, of course, as I mentioned, our Welcoming Schools program is designed to help them fill those gaps. So it really is on the schools now to figure out what actions they need to take to implement anti-bias, anti-bullying, anti-harassment programs to make sure that all students are taken care of. And you've got a lot of resources on this call and beyond to be able to do that in a holistic way.
Yeah, I'll add that in the past, NCT has worked with GLSEN on a model policy for inclusion of transgender, non-binary, gender non-conforming, and intersex students in schools. There's a policy that I believe GLSEN still has hosted on their website that's ready to go for implementation. And one of the easiest ways for schools, school districts, universities to avoid costly civil rights litigation is err on the side of inclusion. There's no need to overthink it. Trans, non-binary, gender non-conforming, and intersex students are students just like all others. Let them participate in the educational programs that they need to participate in. Let them be part of their communities, and you simplify lives for everybody. And your in-house counsel will thank you for it in the long run. The other thing I'll add is that a lot of the organizations on this call do data gathering. NCTE later this year will be merging with Transgender Legal Defense and Education Fund to form a new organization called Advocates for Trans Equality. And later this year, Advocates for Trans Equality is going to be releasing the results of our 2022 US Transgender Survey, which includes surveys on the experiences of high school and college transgender non-binary students, which can be really informative in showing policymakers at the state and local level what kinds of experiences people in their states are having in schools, and that can let them know what they need to address in order to have truly inclusive schools.
Thank you. And I will say, and I haven't had a chance to review this, I know that the Department of Ed in releasing the Title IX rule and the summary had also released resources for schools to be able to ensure that they're effectively implementing this rule. But as been said by many panelists, that's, part of the continuation of our advocacy is to make sure that there is full and robust implementation of this rule. So there's another question for you, Olivia, in the chat about how the rule could be improved to better protect transgender students in sports participation.
So that's a complicated question because, to be glib, one thing it could do is address transgender students in sports participation. Since this rule does not specifically address that, and there was a separate rulemaking the administration engaged in specifically on the subject of athletics participation for trans students, that's just unfortunately really not what's at issue today. The other rulemaking that we're hoping to see still later this year, that rulemaking had, as I recall, well over 100,000 comments just on that. So, when that rule finally comes out, I'd be happy to talk more at length about that. But for right now, unfortunately, just trans student athletes are not covered under today's rule.
If I could add from a not lawyer perspective to what Olivia has expertly said, which is that this rule, as stated, right, prevents categorical bans, errs toward equity and inclusion. And so what I'm hoping that everyone walks away with from this call, from the read of this, the initial read of this rule, is that don't discriminate against trans and non-binary students. So if they need to use a bathroom or a locker room or want to play sports, as just decided in the Fourth Circuit case based on the trans athlete from West Virginia, where the circuit agreed and ruled that she ought to be able to participate, err on the side of inclusion for many reasons, one of which, as Olivia noted, to prevent and avoid costly civil rights litigation. But again, the idea here is inclusion, and until there is further guidance that says something different, then we understand that categorical bans are broadly prohibited.
That's much better said than I did. Thank you so much for that, Melanie. And I'll say that, not only does it prevent costly litigation in the long run, it's also just fundamentally the right thing to do.
Thank you. Absolutely. I want to underscore that, despite the absence of this clear Title IX rule, that Title IX does protect trans, non-binary, and intersex student athletes. And Melanie, to your point about the recent decision coming out of the Fourth Circuit, I just want to highlight that the U.S. Department of Education did acknowledge that these categorical bans violate Title IX in an amicus brief that they filed in that case before the First Circuit.
Sorry, if I can just quickly add in, I was saying earlier by saying that that trans student athletes are not contemplated under this rule. That's also not to say that this rule says anything that you can't have an inclusive policy. You absolutely can, on your own, adopt an inclusive policy. There's no reason for a school to wait until a later Title IX athletics rulemaking comes along in order to do that. Absolutely no reason for that.
Title IX still remains to be the floor, not the ceiling.
Well, now I'm going to look in the chat to see if we have more questions. One thing that I don't see additional questions from reporters, but one thing that we were also interested in highlighting is if Emily and Andrew might be able to provide any perspective or examples of the harms that students faced under the Trump rule and what's likely to change from that, if you can kind of shed light to the direct experiences of students.
Yeah, I think we saw, truthfully, like a wide range of harms that came under these regulations. The vast majority of students that I worked with fell into like 2 or 3 camps. This regulation about not being able to use Title IX for harms that occur off campus was really, really difficult for students. I go to school in Columbia. Our campus is like 6 blocks, and we live in a city very, very large, and go to school with those people even when we are not formally like on school property with them. That produced like a wide range of harms. The standards around harassment was particularly difficult, I think, for young people, when they experience harassment, for example, at the hands of faculty or professors, once is enough to make that classroom feel permanently unsafe. And they often were not covered or given any formal avenues toward redressing that in schools. But I think more than any of that, what we saw was that nearly every survivor activist I know had some experience at some point where they felt disempowered, traumatized, or entirely excluded from Title IX. And the former rules had a chilling effect on college campuses. Many young people heard so many negative stories about the ways that other people's Title IX processes worked that they didn't feel safe coming forward themselves. So I'm hopeful that these new rules will usher in an era where young people feel safer to come forward and get the resources that they need. But I also just want to emphasize, as everybody has done on this call, student activists can't fight for a Title IX that they don't believe in. So we really do need widespread, robust implementation of this rule in order to give student activists any fighting shot to create that cultural change that we need to see to protect survivors.
I think Emily articulated that so perfectly. Those are definitely some of the biggest issues. I think what I saw a lot of and what a lot of people have shared with me and my own experience is because of that sexual harassment standard, right? A lot of people were having their cases dismissed and weren't being provided the supportive measures. And there is so much more access to supportive measures under this rule, which means that people can have access to counseling, they can move dorms, they can take a leave of absence if needed. That really will just sustain them and allow them to continue getting their education, right? Yeah, and I think the other piece there is also like just knowing the process. There's a lot of effort this time to make sure that people are aware of who has confidentiality and who doesn't, so you're not losing your agency. So many people had their cases started because of mandated reporting and of not knowing that Title IX wasn't actually confidential. And so I'm just so excited to see that change under this rule so that we can have students and survivors that have agency and power to decide what they want to do.
Thank you all. So this concludes our our press call. I just wanted to thank our esteemed experts, all of you, for sharing your expertise, your reflections on this rule. It is a very lengthy rule and there is a lot to go through. And I know many of you are still digging into it. So thank you for your time. And thank you to the reporters and everyone else who joined us and asked really important questions about this rule. Hope you all have a wonderful weekend.
Thank you all.
Thank you.